Thank you. Thank you, Mr. Ruben. All right, we'll move to Michael Blatcher. Sorry.
I've been called worse.
An attorney with Liebert, Cassidy, and Whitmore.
Thank you, Mr.
Morning.
Chairman. Mr. Ting. My name is Michael Blatcher. I'm a partner at Liebert, Cassidy, Whitmore. We're a California law firm with offices in San Diego, LA, San Francisco, Sacramento, and Fresno. My firm represents about 200 private schools in the state. About 40 of those are religious schools. They cover a very broad spectrum of beliefs. We represent a number of Islamic schools. We work with Orthodox, conservative, and Reformed Jewish schools. And we represent Christian schools from various denominations. Theologically, these schools could not be more different. Each has its own history, traditions, and customs. Some of these schools would be considered very conservative, both religiously and politically, and some would be equally liberal. But we love them all. Every chance I get, I leave my office to go visit our clients, and I often spend time in the classroom. When I'm there, the lessons I hear are frequently in languages I don't understand, retelling a history I don't know, about beliefs I don't share, followed by food that I won't eat. But these experiences inspire me. The employees, virtually without exception, are driven by a sense of mission. English, history, science, and math are a critical part of the student's education, but those lessons are ancillary to the religious purpose of these schools. The unique focus and singular objective is to perpetuate a sense of shared history, beliefs, and values. That is their purpose, and it's transmitted each time our clients teach a course and whenever they appear in their roles as emissaries of the faith. Though our clients may appear very different, they're also very similar. Whether I'm speaking to elderly Holocaust survivors who teach about their experiences as a persecuted religious minority, or young refugees from the civil wars in Syria and Iraq who have found a community here in California, one refrain I hear uniformly and passionately is how fortunate they are to live in a country that protects their religious freedoms. It means they can be a part of a religious community that embraces their beliefs, that teaches their values, and shares their view of what they believe the world should be, even if it's not always the way the world actually is. Religious tolerance and freedom is perhaps a uniquely American value, and one that has been a part of our shared history and our collective beliefs since this country's founding. I don't want to spend my time going over in great detail the ins and outs of the First Amendment or even of the Hosanna Tabor decision. You've already heard a little bit about that, and you have the excellent background paper that's been prepared for this committee. I've prepared a PowerPoint, which you have, and I'm only going to discuss a few of the slides that are on it. One of my favorite quotes from a ministerial exception case is the one that's on the screen now. It's a Ninth Circuit case. It says, rabbis are clearly ministerial, but what about the gabbai and the shamas? And if you don't know what a gabbai and a shamas is, then I think that's sort of the point. And if you do, mazel tov. What about the cook in the synagogue's kitchen, who may have unorthodox views about whether swordfish is kosher? It's because some would consider swordfish kosher when it's young and not kosher when it's full grown. And our moils, a moil is somebody who performs circumcision, to be cut off from the ministerial exception altogether. The point of the slide, and really the point of the case, is that it's difficult to know who's a minister. It's not always clear to an outsider when somebody is performing a religious function. And that's something that really has been recognized by the courts for some time, that even having the government intrude into the religious functioning of an organization and decide for itself what's religious and what's not, creates what's known as entanglement problems. So in the decision of Hosanna Tabor, it's already been mentioned, it was a unanimous decision. That's not something we see often. The court noted that the teacher in this case only worked on religious issues for about 45 minutes a day. There's a concurring opinion by Justice Alito, who, and I just wanted to clarify, in my opinion anyway, he's considered a very conservative justice, and Justice Kagan, who is considered a very liberal justice. And even on this issue, they agreed. And they both signed a concurring opinion, which I think in the cases since Hosanna Tabor has really been considered very carefully by the courts who have looked at this issue. And one of the things they noted is that, even referring to this as the ministerial exception is itself problematic. They noted that not all religions have ministers, and they devised a way of addressing this issue where the focus is really more on the employees and what it is that they're doing there. They also discussed, and I wanted just to emphasize the point briefly, that a pretext argument. In other words, you're saying, well, the reason that a person was terminated, for example, or treated differently was not really religious in nature. That's something that's not permitted under the ministerial exception. The court in Hosanna Tabor was clear about that, and Justices Alito and Kagan felt that was so important that they wanted to make that point for themselves. Finally, I wanted to end with this quote. It's just been on my mind as I was preparing for this informational hearing today. It's a quote by the legal director of the ACLU. And when I read it, I'm reminded that, at least for myself, when I learn about different religious beliefs, to me, they often seem antiquated. They often seem wrong. And they can even seem offensive. But I think it's in those cases, when we're dealing with those very issues, that we need the First Amendment the most, that we need its protections the most. And I hope you'll keep that in mind. Thank you.
Thank you. So that brings us to Kathleen Purcell, who's a former teacher at Bishop O'Dowd High School in Oakland.
Yes.
Welcome.
Thank you, Chairman Stone, Assemblymember Ting, Mr. Clark. I'm a high school teacher and a constitutional lawyer. I actually keep running away from law to go work with teenagers. And what I'd like to do today is not talk about the law, but to give you a sense of what this means on the ground and what the human cost, what's really at stake here. I came to teaching after many years of practicing law. From early on, my law practice involved anti-discrimination work and First Amendment work, particularly free speech and freedom of religion. It also included other public policy work and other constitutional stuff. But I've been involved in high school teaching since 1989. I'm very old also. I worked for 7 years at St. Ignatius High School here in San Francisco. I taught history, and I worked in campus ministry. I've also worked with the public schools here in San Francisco. I know the difference between a teacher and being a minister. Most recently, from 2008 until last year, I worked at Bishop O'Dowd High School in Oakland. It's a diocesan high school in Oakland. At O'Dowd, I created a career and college exploration program. I ran their international students program, which meant many students from China who had no religion whatsoever. And I also taught history. I taught U.S. history. If I have one message for you as a lawyer and as a teacher, it is this. Focusing on the U.S. bishops for the moment, they very much want to characterize what is at stake here as freedom of religion. That is not what is at stake. These Catholic schools have entered the public square They are not functioning as churches. They are not functioning as religious enclaves or as missionaries. They actively solicit the general public, Catholic and non-Catholic. They want all the benefits of being part of the larger society, economic, political, social, but none of the responsibilities. Freedom of religion is not a broad license to discriminate, and it is not a license to abuse the trust and the well-being of our children. And that, I suggest to you, is what is really at stake here. So here's what happened in the Diocese of Oakland. As the 2013-14 school year was closing, the Bishop of Oakland announced that he was inserting into our employee contract new language. It was brand new language. Under the new language, our overarching commitment as teachers would supposedly be to promote, quote, the doctrines, laws, and norms of the Roman Catholic Church. That was not in any way what my job was. It's not what I had done for the past 6 years. It's not what I knew other teachers, science, math, English, social studies, even many of the religion classes, upper division classes at these schools are accredited by UC. Part of that accreditation is that they not be inoculation of religion. This is not what teachers were expected to do in their classrooms. There was also new language that made it a condition of my employment that in my personal life, in all its aspects, I must, quote, model and promote behavior in conformity with the teaching of the Roman Catholic faith in matters of faith and morals. The bishop's action threw our school into uproar. Teachers were deeply distressed, and they were very, very afraid. The details of their personal lives were suddenly open to scrutiny and could be the basis for adverse employment action, including firing. With my knowledge of constitutional law, I also recognized the ministerial exception issue and that all our rights under the anti-discrimination laws could be at stake here. A little over 2 years ago, a very dear friend of mine died. I gave one of the eulogies in which I celebrated her 40-year relationship with her lesbian partner. That eulogy would be in violation of this new contract. Putting a no on Prop 8 sign in my window, putting a Barbara Boxer or a Nancy Pelosi or a sign supporting some of the members of this committee would potentially put me in violation of my contract. Now, you think I'm kidding, but the Bishop of Denver threatened to excommunicate and evict from their home a group of nuns who put an Obama poster in their window. The Archbishop of San Francisco has said mere membership in a political party is okay, but depending on what your political activity is, we'd have to look at it case by case. The O'Dowd students and their families, not just the teachers, were stunned at what was an assault on the explicit culture of that school, which was a culture that said diversity, acceptance, safety, critical thinking. It was under siege, and they were worried about their children. They were worried about the teachers, too, and they were worried about themselves. You need to know that Bishop O'Dowd and the schools here in San Francisco and Catholic schools in cities, high schools particularly, but not just high schools, in cities across California are 25% or more, in O'Dowd's case substantially more than 25%, not Catholic. They're Buddhist, Protestant, Jewish, non-Catholic, no religion at all students. And they are not only invited but sought after by these schools. The teachers, by no means explicitly Catholic. Many non-Catholic teachers, Protestant, Jewish, Buddhist, no religion at all. The promise that is made to these non-Catholic families is that the school will not try to convert their children. They demand that the children be respectful. My international students who really didn't like taking religion classes were told by their teachers, by me, and by others, you have to be respectful, you do not have to believe. Treat it like a philosophy class. The promise that these schools make to their LGBTQ students, to students with gay and lesbian parents, to students who are the product of in vitro fertilization, or the many families at these schools who are otherwise arguably out of step with Catholic norms, is that their children will be safe, they will be treasured, they will be supported. After the bishop's action, there was a survey of the faculty and staff at O'Dowd. Only 4 employees were not concerned. The new language concerned 62 of the employees who answered that survey, and here's some of what they said. They were worried about the impact on our ability to support all of our students, including those who are non-Catholic or even non-religious, who are gay or lesbian. They were worried that the language is so broad it will be impossible to enforce fairly and will be used to go after those who are most visible or vulnerable. They were worried that a student or family with academic issues could use the new language to attack a teacher's lifestyle instead of dealing with the academic issues. The Oakland bishop and school leaders attempted to quiet the concerns. They said, this is not a witch hunt. Nothing will really change. They told us basically to ignore the legal language in the contract and trust them. Just sign the contract. The most the bishop offered was that he would initiate a series of meetings the next year to consider revisions to the language. I loved my job at O'Dowd. I loved the community. I loved the culture. I could not put my name to this language. I could not be complicit in stripping employees of their privacy, their integrity, and their rights. It was a cruel choice for me. You can see I'm a little surprised at my own reaction, but it was a cruel choice for me. But I tell you, it was an even crueler choice for my colleagues, many of whom have young families, mortgages, and don't have options. It's not really voluntary. Ultimately, what I did was I crossed out the language. I signed it and I submitted it because I wanted to work there. The diocese took the position that wasn't a contract, and my employment was terminated. Now, San Francisco. The Archbishop here likewise has tried to use the contract. In this case, it's a union contract. I think it may be the only Catholic teacher union in the state. I may be wrong. To create evidence to support this ministerial exception. He also wants to rewrite the teacher's handbook. And his first rendition included language that many of us would consider hate speech. He stated that the schools affirm and believe that adultery, masturbation, any sexual relations outside of marriage, and homosexual relations are, quote, gravely evil. It also used words like disordered and intrinsically evil. Artificial reproductive technology, contraception, and abortion are described similarly. Well, San Francisco responded, and you know a lot about that, with outrage and with organization. 80% of the teachers at the 4 archdiocesan schools signed a statement that the language is, quote, harmful to our community and creates an atmosphere of mistrust and fear. The Archbishop has forged ahead. He's softened the language, but not a change in course. When specifically asked whether he would act against teachers for how they live their personal lives, he responded that he would have to consider each situation case by case. He says he wants teachers to be careful about what they say to students so that it doesn't contradict his version of Catholic teaching. I ask you to think about what that means for the gay or lesbian student who is struggling with depression. What happens when that student goes to a teacher for support? What happens when an adult at the school refers to homosexuality as bestiality, and it has occurred in the past? And a teacher may challenge the word, but apparently not the idea. What happens to the silent, vulnerable student sitting in a classroom discussion when a classmate insists that gay families are disordered and that and gravely evil, or that the children born of in vitro fertilization are a product of sin. And the teacher can't respond according to handbook and contract. The situation created by these bishops certainly harms our teachers, but it threatens our children as well. And so I invite you to look through several lenses and several aspects. Yes, the employment and civil rights of teachers, the privacy rights of teachers, also the emotional abuse to our children, questions of fraud and manufacturing evidence to support this ministerial exception, questions of false advertising and how the schools are holding themselves out, speaking through both sides of their mouth, making promises that teachers have to break their contract to keep, and whether and where these institutions that demand the right to broadly discriminate are being supported by public resources and public funds. What we have here is not employers using the First Amendment to protect religion, but using it as a sword, not a shield. They have taken what's supposed to be a very limited exception and are trying to stretch it until someone, either a legislature or a court, tells them to stop. And a lot of people are being hurt along the way. So what I ask from our legislature is to find appropriate ways to reinforce what should be obvious, which is that being a church-affiliated organization is not a license to discriminate or to abuse our children. I thank you for giving me this time and for creating this hearing.
All right, thank you. Hold on. This is an official hearing of the legislature. Outbursts like that will not be tolerated. If you agree with the speaker, wave a hand, but I will not have this. Thank you. Hearing interrupted. Thank you.